When can schools expel a student for lying? What happens when a student's initial lie snowballs into a tangled web of police reports, intimidation, and false accusations? We've talked about smoking in the girls' room, but what about vaping in the girls' room?
Oh, vaping in the girls' room. Here we go. So the smoking in the girls' room case, that was TLO. We covered that one. That was the famous search case, New Jersey versus TLO. In episode 15, we covered that one. And now we're bringing TLO into the 21st century with this one. This is a case about a student who was thought to be vaping in the bathroom, but then decided to make a bad situation worse by doing some lying and intimidating a fellow student. That's fun. Yeah, so this is the case of Ashton versus Okemos Public Schools. I think I pronounced that right.
A lot of confidence there. Yeah, you ran right at that.
Well, go big or go home. Welcome to Chalk and Gavel, everybody, where we explore how the law shapes education one case at a time. I'm Jamie Cudlitz, a former middle school math teacher and principal.
And I'm Chris Thomas. I've been a high school English teacher and a school attorney. Now we're both professors of educational leadership, bringing you the fascinating stories connecting the courtroom to the classroom.
Chalk and Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
The kids are alright. The kids are alright. The kids are alright.
All right, welcome back, everybody. Just a quick reminder, please rate and review Chalk and Gavel. If you're checking us out on YouTube, please give the video a thumbs up. That would help us spread the word. We also have a teaching guide available on our website, chalkandgavel.com, and we would love it if you would consider supporting the show on Patreon for just $2 a month. That would go a long way to help us keep this thing going. So go to patreon.com/chalkandgavel, and that will help us bring you all of this fun school law stuff over and over and over again. So, Chris, what's our bell ringer today?
Speaking of fun school law stuff and Groundhog Day episodes.
Again,
yeah, but this is a fun one. So I've got a fun and timely update on what we talked about last episode 51, on Louisiana's 10 Commandments law. So I think we mentioned that Texas had also passed a similar law not too long ago. Yeah. Well, guess what? That's also been subject to a lawsuit.
Hey,
I know, right? Who would have thought? So that law also requires schools in every classroom to display a poster of the 10 Commandments. It's pretty much identical to Louisiana's law, except here's where there's a very distinct Texas difference. The Louisiana law requires that the poster be 11 by 14 inches, right? So like a little bit bigger than a piece of paper.
Right.
The Texas poster, though, had to be 16 by 20 inches.
Ooh. Everything's bigger in Texas.
Right. Because Texas, right? Yeah. Texas probably saw that and they're like, we could do that better and bigger. Also, the Texas law didn't require that the posters be accompanied by that kind of secular statement about the role of the 10 Commandments in American history. That was completely absent from Texas. So Texas just required the 10 Commandments by themselves.
Yeah. Go big or go home. Yeah.
And that's exactly what it was. And turns out they're going home because just like Louisiana's law that was blocked by a federal court, a federal court has also blocked Texas's law from being implemented. So they granted a preliminary injunction pausing Texas's law, though it only applies to the districts that were part of the lawsuit. So it doesn't apply to all of Texas, but my guess is we'll probably get there.
Yeah.
So according to the court, they relied on Brumley, which was the case we talked about Louisiana from episode 51.
Mm-hmm.
And they said that the 10 Commandments requirement from Texas violated the Establishment Clause because it was impermissible coercion and it lacked historical precedent. So they had kind of experts say that like, hey, this wasn't part of historical education. You can't add it now, essentially.
That's actually kind of interesting. I wonder if they kind of threw that in there in light of this history and tradition kind of religion.
It's 100% because of that, where like we've gotten our marching orders from Kennedy versus Bremerton to like look at history and tradition to see how all of this stuff is played out. And so these courts are saying like, basically they're saying
they're getting out in front of it. Yeah, a little bit, right?
Anticipating counter arguments, right?
Yes, exactly.
Basically, they're trying not to get overturned by the Supreme Court, which I applaud them for.
Good luck.
Yeah. Right. So this opinion is really interesting because it starts where judicial opinions don't usually start, which is the history of religion. Really? And then it talks about the history of religion in the United States and all the way up from like the founding to today. And then it gets into its legal analysis. So like, this opinion took it seriously to like look at history and tradition.
Okay.
It also cites Sonny and Cher, Kenny Chesney, and Kurt Vonnegut.
Are you kidding me?
No, they're all cited in the opinion. You know, a well-researched and lots of good citations in this opinion. Always just impressive when judges can fit stuff like that into a judicial opinion.
I'm so curious now, like how do you fit in I Got You, Babe? Into, or was it something else?
Yeah, I don't think it was I Got You, Babe. I forget exactly. The Kenny Chesney one was Everyone Wants to Get into Heaven or some variation of that. Right. Kurt Vonnegut, I think, was Slaughterhouse-Five. I forget the Sonny and Cher one. But yeah, they're all in there. So yeah, if you're curious, you can check out the opinion in Nathan versus Alamo Heights Independent School District.
All right. Fantastic. Well, that's a great update and very timely considering what our episode 51 was about last time around.
Yeah, and add another one to the Groundhog Day.
There you go. It doesn't stop. It just doesn't stop. All right, let's get into this one. All right, so today's case takes place in the Okemos Public School District. Again, said with a lot of confidence, but I was going to say,
I think you said it differently this time, actually.
Did I?
Okemos.
Oh, now I'm second guessing myself.
I'm sorry, I got in your head.
All right. So this case takes place in Michigan. If you're doing the hand map, for all of you who don't know, there's a fun little hand map thing that you can do with Michigan. And it's kind of like right there in the lower third kind of center near the university or Michigan State, not the University of Michigan, Michigan State University. Right. They're very
both fine academic institutions, but one has a better football team.
Okay. I ain't going there.
Go Bucks.
So one of the rankings has this public school district as the 6th best district in Michigan. So probably a pretty good school district. And this story starts in 2021 when school officials started taking some measures to curb vaping and e-cigarette use at the high school. All right. So obviously this is a very big thing now. And one of the reasons is you can't smell vapes the same way you can smell cigarettes, or at least vapes don't have that, distinct cigarette burning
They can
tobacco.
smell like lots of other stuff, right?
Smell, right. Yeah, it smells. Blueberries.
They're also easier to hide.
You don't have to light something on fire. Like it's a whole problem in schools, right?
And you also don't know what's in them in a lot of situations.
Oh, yeah.
Tobacco, something else.
Yes, that. Yeah, a whole host of problems with vaping in schools. And, this is probably not news to anybody.
Right. And it was kind of an epidemic, like right around this time. That might not be the right word choice because of what else was happening right around this time. But like, I know school administrators across the country were struggling with how to deal with just like the surge of vaping in schools.
Yeah. Which has not necessarily declined.
Sure. Hopefully we've got better strategies now.
Well, I know they make equipment to detect vaping. They've got like vape sensors and things like that. There's all kinds of stuff. But I think from a, cost and efficiency and reliability kind of issue, there's a lot of schools that don't employ a lot of those technological kinds of innovations and, just rely on standard word of mouth and evidence and
kicking down doors in the bathroom.
Exactly.
Yeah. And 2021 was also, this was the school's first year coming out of the COVID-19 pandemic to return to in-person classes. And that itself came with a whole host of issues as well.
Yeah.
So like being a school administrator in 2021 with all these issues, probably not the easiest job.
No. But anyway, officials at the high school, they instructed staff to engage in spot checks of school bathrooms to kind of ensure that, nothing nefarious was going on, right?
Right. Because it's always the school bathroom, right? TLO taught us that.
It is. That's a great place to hang out. So those spot checks generally involve staff just kind of taking a brief look underneath the bathroom stall partitions from the public areas of the restroom. So just like go into the restroom and kind of dip your head low and look to see how many feet you see in a stall. Because if there's more than one pair of feet, something's
that's not
going
how
on.
those work.
Okay, so that all started in 2021, and in the spring of 2022, so that same school year, we've got somebody. Her name is EB. All right, she's a minor, so
those are probably her initials.
EB, probably, yes.
Probably not her name.
No. So she's a sophomore at the high school, and now we don't really know very much about EB as a student or how she was from a disciplinary standpoint prior to this. So all we know is sort of what happened with this event moving forward. So what happened was on April 8th, EB was searched by school officials. Now, what had happened was another student told a teacher, Miss Cerrone, we think we're pronouncing that correctly, Miss Cerrone, that several other students, including EB, were vaping in the school bathroom. The student was upset because one of the other students had blown smoke in her face. So she was like,
great.
Screw this. I'm telling on you people. So Miss Cerrone and the assistant principal, Dr. Sharp, investigated the incident. They called EB down to Dr. Sharp's office and asked her about the rumor about whether or not she had been vaping. So EB denied it. She said, no, wasn't me.
The classic Shaggy defense.
Yeah. And there it is. So Dr. Sharp then performed a no-contact search. So what does a no-contact search mean? In this case, it was a visual inspection of her waistband and outer clothing, so no touching. They asked her to pull out her pockets so that they could see if, anything was in there that shouldn't be in there, and having her lift her pant legs up so that administrators can look into her shoes and socks.
Okay.
So non-touching kind of just, hey, let me visually inspect some areas of your person.
Right.
And not
this sounds
taking off clothes or anything like that.
Oh, right. Yeah. This sounds almost identical to TLO, right?
Yes.
Like these are the exact same facts. There's somebody accused of smoking or vaping in the girls' room
who denied it.
And then they do a minimally intrusive search.
Yeah. So this is a good point to kind of remind everybody about how we handle searches in schools and sort of what this TLO standard provides us and has provided us for many, many years. So TLO says that for a search to be constitutional, it has to be justified in its inception. So we have to have a decent reason to believe that a rule might have been broken. Okay?
Right. Articulable suspicion.
Yes, it doesn't rise to the same standard as, a police search or whatever, okay? But we just have to have some suspicion that a rule was broken. All right? And the search has to be reasonable in scope, which means you've got to be sort of looking for the thing that is potentially going to prove that the rule has been broken based on the suspicion that you have. So if you pull somebody out of a bathroom because you smelled smoke coming from the bathroom, you don't go and search their car for cigarettes.
You can't search their cell phone, right? Yeah, exactly.
Yeah, exactly. Because it's kind of unrelated to the circumstances that cause you to believe that a search needs to be performed, right?
Right. And the more significant the thing that you're looking for, the more intrusive the search can be.
Yes.
So if you're looking for like vapes or, Safford versus Redding is another classic example. If you're looking for over-the-counter pain meds, that probably is like Advil, like that's a less intrusive search. But if you're looking for
heroin,
illegal drugs, or a weapon or something like that, maybe you can do a more intrusive search.
Exactly.
Right, exactly.
That's the basic issue and sort of parameters, right, around searches in schools. Okay. And the main reason is because everybody has this expectation of privacy, right? And depending on the circumstances, that expectation of privacy, it varies, right?
Right. Yeah. And the government can't intrude upon that without kind of without being reasonable, right? That's what the Fourth Amendment says. And as long as it's a reasonable expectation of privacy, meaning that like you think it's private and society is willing to recognize that it should be private.
Yes.
That's something that's going to be protected. So like, your unclothed person is like the thing that you probably have the strongest privacy protections for.
Yes.
But, we've also recognized privacy protections for like your purse or your car or your house, right? Like all of those things are things that we expect privacy in, right?
But to different degrees.
To different degrees, right?
Yeah. So anyway, everything's sort of following along with sort of the guidelines set out in TLO.
I was going to say, this sounds exactly like TLO, and TLO was constitutional. So we're good so far.
So far. But here's where everything goes off the rails.
Is this where it goes off the rails?
Well, it goes off the rails.
How many rails are we going to go off
There's
today?
a lot of rails, and it goes off every single time. So unlike TLO, they find nothing. The search turns up nothing. Okay. No evidence of wrongdoing. EB goes back to class. No discipline. End of story, right?
Never.
No.
This is chalk and gavel.
That's right. It didn't end there. So EB goes home later and tells her mother and stepfather about what happened. Hey, I was accused of vaping and I got searched or whatever. So the mother and stepfather, they complained to the assistant principal that they weren't notified about the search, which they don't need to be.
Depending on, there might be state
depends
laws
on
or
discipline.
School policy, right?
Yeah, state laws, school policy, whatever. But in this case, there's no, TLO didn't mandate, for example, that parents be notified whenever a search is conducted.
Right. Not legally required. Maybe not a bad idea because...
Exactly. Which is a good point to kind of reinforce right now. Just because you aren't obligated to do something under the law doesn't necessarily mean that you shouldn't, and in this case, maybe you should have, maybe you shouldn't, neither here nor there at this point. Anyway, they weren't notified. They weren't happy about that. They have a discussion with the assistant principal. They didn't like the explanation that the assistant principal gave, which is going to be pretty important because of what happens next.
Right. And I think that that miscommunication, I don't even know if that's the right word, but the parents being disgruntled about this initial thing, I think is probably one of the things that snowballs the rest of this case.
Right. The fact that it doesn't get resolved at this point is...
Well, not even the fact that it got resolved, but there's a challenge with the relationship here.
Well, that's what I mean.
Yeah. Oh,
that's
the relationship doesn't get resolved. Yeah.
The fact that this situation did not sort of come to an end at this point, which with everybody just saying, okay, stuff happens and blah, 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 no harm, no foul. We didn't find any evidence of wrongdoing, but, we were within our rights to do this. And, but a lot of that, we have no idea how that conversation went between the parents and the assistant principal. We don't know if it was contentious. We don't know if it was contentious. We don't know which party or both were contributing to the contentiousness. If it was.
Yeah. All we know is that the parents left not satisfied.
Yeah.
Right.
Exactly. So about a month goes by, and in early May of 2022, it actually was on May the 4th. So
May the 4th be with you.
There you go. I don't think we've done a movie reference in a long time.
It's been a couple episodes for that too. Yeah.
So
look at us returning to the classics.
There you go. It was a little stretch. It's not so critical to the case, but hey, we had to throw it in there. So on May the 4th, be with you, things take another turn. So Miss Cerrone, that the same teacher that was monitoring the hallways during the lunch period when she was monitoring the last search, was monitoring the hallways again and saw several students walk into the bathroom together. Okay. And she did some quick math. I don't know if she was the math teacher or not, but she did some quick math and concluded that was too many kids for the number of stalls and everything that were in that bathroom.
Right. So, yeah. When kids go to the bathroom in groups like that,
they pretty much always do, though. That's a very common, especially with girls, right? They go to the bathroom in groups.
Mm-hmm.
Anyway, it was enough to prompt Miss Cerrone to say, you know what, I'm going to go check that out.
Right.
So now we end up getting divergent stories. We've got the kid's story. We've got Miss Cerrone's story. So here's Miss Cerrone's story. Miss Cerrone said that she walked in, she talked to a group of students that was hanging out in the common area, the public area of the bathroom, so like probably near the sinks and things like that. She knelt down to look under the stall partitions, and she said she saw one set of feet in one of the stalls. Now, to get a better look, she moved a little further into the bathroom and knelt down again, but didn't approach the row of stall doors. Okay. And then she completed her check and walked out.
So, right. So if I'm thinking about the TLO two-pronged approach, justified at its inception, like she's just like, she's suspecting like there's a pattern of people vaping in the bathroom. A bunch of kids went in there, potentially suspicious. Cool.
It seems so totally safe to me.
Right. The scope thing is where like, I think it's going to get really interesting because like
she knelt down, she saw one set of feet, and then she went further.
Right. And it could be like she went further to get a different angle on it without getting any closer. Right.
Yeah.
Like, so basically just to see like, okay, are those feet blocking other feet?
Yeah. And it doesn't matter. You know why? Because EB, who was in the bathroom, told a very different story.
Okay. I'm imagining like Tarantino, like we're doing some time stuff. So like,
oh yeah, that would be fun. Yeah.
Rewind it now.
Yeah.
And like,
if we had the budget, maybe we would do our episodes like that. But it's just me and Chris, man. This is all you get. So EB tells a different story. She said that she went into the bathroom stall with another student. So she says she was in a stall with somebody else, even though Mr. Only only saw one set of feet. So she went in the stall with another student, SN are the initials of that student, to talk about a third student, AL, who was not in the stall with them. She was outside of the stall. Okay, standing guard.
But they were talking about her while she's like 4 feet away?
Listen, man.
It's been a while since I've been in high school. So
yeah. So EB and SN, they're in the stall. They're talking about AL. She said that SN sat on top of the toilet so that she couldn't be seen from outside. So they knew.
So they know what's up.
Yeah, they know what's up. They know two people shouldn't be in the stall at the same time. EB said that they were just talking. They weren't vaping. It's just a little bit of a funny aside here, but the court editorializes here and also adds that neither, quote, were they using the bathroom for its intended use, and they did not remove their clothing while in the stall. So they weren't in there for anything that the stall was supposed to be used for.
Okay. Good. All important details.
So while EB and SN are in the stall, EB heard Miss Cerrone come in and recognized her voice. She heard Miss Cerrone ask the student on guard, who was AL, how many students were in the stall, and AL, sort of as a loyal friend to EB, I guess, said, no, there's only one person in there. So Miss Cerrone leaves the room. EB and SN get out of the stall. EB talks to AL, who told her that Miss Cerrone looked under EB's stall. EB said that she assumed that this meant that Miss Cerrone had approached the front of the stall and bent down to look underneath the stall. That was an assumption that EB made.
You know what happens sometimes when you assume?
Yes.
You're wrong.
Yes, you're wrong. You make a you-know-what out of you and me, right? That's everybody's English teacher.
I was going to say, every teacher has said that.
Yes. So this leads EB to text her mother that, quote, one of the staff members looked under the stall.
Which isn't necessarily a lie at this point.
But it's not untrue, but it's not the most accurate telling
Perhaps
of
it's misleading.
Yes, I would say that. And would you say that her mother was actually misled by that? Oh, I would say so.
Yeah, what happened next?
Mom got upset.
Naturally, right? If you got that text, right?
Yeah.
Especially if you're already not having the best relationship with the school, right?
Yeah. And now you've got this sort of impression that staff members are peeping in on kids using the bathroom. Mom and stepdad were not happy, so they go to the school to talk to the leadership there. They get to the school, they talk to the assistant principal again, who again, they weren't satisfied with the last time. There aren't any details really about that conversation, but later the assistant principal talked to Miss Cerrone about the parents' complaint, and Miss Cerrone then called the parents to explain the reasoning behind the bathroom checks. On the call, Miss Cerrone explained that she had not gone past the sink area when conducting the check. So basically, the conversation between the parents And the assistant principal potentially included the assistant principal saying, listen, I wasn't there. I can't tell you exactly where Miss Cerrone was or how she conducted that search, but I would encourage you to ask her that question.
Right.
Which they
or
did.
the AP then went to talk to Miss Cerrone, reported back.
Something
right?
to that effect.
And,
right.
you know, for like legally, it does matter where she was, right? Because like,
yes,
if
there's the invasion of privacy piece, right?
Right. It goes to that intrusiveness scale or like the scope issue, right? Because if you are like right up against the stall looking under it, like that is a much more intrusive search. But if you're like at the doorway, just kind of like gazing towards the stalls and you see feet, like that's not intrusive at all.
Exactly. So at this point, EB is, you know, I guess you would say she's kind of invested in the lie. She's going to double down here.
This is where things snowball, I think.
Yeah, I think so. So she tells her parents that Miss Cerrone was lying based on how she interpreted what AL told her. Okay. So maybe it was to make her story more believable. Who knows? EB adds 2 very interesting details at this point. She tells her parents that 1, she could see Miss Cerrone's hair through the crack in the stall door.
Oh.
Mm-hmm. And 2, that she was actually using the restroom when Miss Cerrone looked into the stall.
Now, wait a second.
But EB had said previously they weren't using the bathroom.
And there was another student
student in there.
Right. So like we know for a fact that EB knows that the second one is false, right? Like,
yeah.
So that is a lie.
Yes.
You know that EB is lying now.
Yes.
And then, you know, from the first one, like
the first one is just like a he said, she said kind of.
Right. And maybe it's possible, like I saw your hair, but you know, it was 20 feet away.
Right. Exactly.
Right. But the way the implication is that it was like right up against the partition.
Right. And from what EB had said before, she was relying more on AL's account of who was out there and all of that stuff. And she had said she heard her voice. She didn't say initially that she saw her hair.
Right.
So we're really on some shaky ground here. Regardless, the parents are hearing this. They're very upset and they do not trust the school. So they don't trust the school to kind of get to the bottom of what's going on with these conflicting stories. And so EB's stepdad decides to report this to the Meridian Township Police Department.
Okay, now that's an escalation.
That is definitely an escalation.
But given like, I guess, if you assume EB's story is true, it seems in line if you don't think the school is going to adequately resolve it, right?
Exactly. You think the privacy was invaded in a pretty serious way in the bathroom. While the kid is using the bathroom, a teacher is peeping in and the school doesn't seem to be doing anything about it. So he decides to talk to the police department. He speaks to an officer there who happened to be a school resource officer. He reported that EB had been part of an inappropriate situation involving Miss Cerrone, and that she had looked under EB's bathroom stall while EB was urinating. Okay, which again, we know.
Not the case, but that's what she said.
Right. He also added another new detail. There's a lot of new details that just keep showing up here.
Yeah, based on firsthand experience too.
Exactly. EB's stepdad reported that Miss Cerrone, quote, locked eyes with EB.
What?
During the inspection. Well, that came out of nowhere, huh?
Right? Like,
right?
Nobody has said this at all. And now it's the stepdad saying this?
Yeah. So the officer goes and talks to EB, who admitted that she had not seen Miss Cerrone and was just reporting what her friend AL had told her. So now, like, she's even going back on, like, oh, I guess I didn't see the hair.
Right. So now the officer knows that, like, there are different versions of the truth at this point.
Right. Right. And it's not looking, and the officer knows at this point, it ain't looking good for EB's side of the story.
Right. Because it's already contradictory.
Yeah, exactly. Yeah. That's where the truth seems to be falling apart. So the next day at school, EB meets with AL. Remember the student that was guarding?
Mm-hmm.
In the same bathroom, because, hey.
Right. Go back to the scene of the crime.
Right? And asked AL to reenact the incident. So EB is like, okay, let's go through what happened here.
So either she's like trying to figure out like, oops, did I make a mistake? Or she's trying to get her story straight.
I'm going with option B, Chris, just given how everything
let's see
is
what
kind
happened. I'm going to keep an open mind.
Yeah. So EB said that after watching AL reenact the whole thing, she realized that Miss Cerrone had not stood directly in front of her stall at all, and that she had assumed that she did the day before. So she's like, oh, okay. So my accounting of the event of, her coming right under and peering underneath the stall and locking eyes and seeing the hair and all that stuff, that ain't going to fly with AL's account of how everything went down in the bathroom. So EB just decides, okay, it's time to move on. I'm done with this whole thing, right?
Awesome.
No.
We got more rails to go off of?
Yeah, we've got some more rails here. So later that day, EB sends AL a text message asking her to lie for EB and tell school officials that Miss Cerrone was indeed by the stall when she knelt down to count feet. And she did this with, quote, the objective to get Miss Cerrone in trouble. That is a direct quote from the text exchange.
Oh, EB, what are you doing?
Oh, yeah, she ain't thinking, I'll tell you that right now.
Well, she's thinking too hard, right? Yeah, at this point, she's throwing good money after bad.
Yeah, no, it's...
She's digging her hole deeper, right? Like,
yes.
To mix our metaphors, because we're great at that.
Yeah. So, in a text,
I hope nobody sees that text.
I wonder if somebody sees that text. Well, they obviously did, because we're talking about it. So that same day, the officer who investigated the incident investigates, the whole thing. The officer who was involved in the beginning part of all of this investigates. And he had another conversation with EB's stepfather in which he again reiterates that Miss Cerrone locked eyes with EB while she was on the toilet. Okay. So the stepdad is doubling down on this as well.
Right. And maybe he's just trying to get people to take it more seriously, but like that is very problematic, right? Like
right.
basically fabricating facts
and then just repeating them. Yeah. Yeah. So officer goes to the school, interviews AL this time.
Okay.
Because AL approached the school principal saying that she had information about the situation. So AL is probably not feeling all that great about how all this stuff is going down.
I can imagine she just doesn't want to be in the middle of it. Like, this is turning into a mess.
Who knows? Or maybe the stuff that AL and the other student were talking about, maybe she found out about it and she was pissed. I mean, like, who knows?
Right. This is high school, after all.
Exactly. Like, it could be a lot of things, but at the end of the day, AL decides, I ain't feeling good about this for one reason or another. I'm going to go tell the principal. Okay. And so during that interview, AL told the officer that Miss Cerrone had not approached EB's stall and that EB had asked AL to lie for her. And she even showed Officer Leroy, that was his name, the text exchange between her and EB. All right. So
and
now
there's nothing that says I'm lying, like asking someone else to lie for you.
Yes. And then nothing that proves that you're lying more than showing that to a police officer.
And also, like, EB said she went into that stall to like gossip about AL, who was standing 4 feet away on the other side of the stall door. Like, maybe that's not the way to engender trust.
No, this
right, and a potential co-collaborator.
So Officer Leroy then asks EB's stepdad to bring her to the police station to be interviewed. And at the station, it gets serious.
That's a really good strategic choice for this officer, though, because like he knows she's lying at this point, and the gravitas of being there.
Yeah.
No.
So she's interviewed at the police station. At first, she sticks to her story and tells him that Miss Cerrone had stood in front of the bathroom stall when she bent down to look in. But then later, who knows what Officer Leroy said? Maybe he said, no, I think you're lying, or I know you're lying, or who knows what. But later on, EB admits that she wasn't telling the truth.
Oh, okay. Good.
So at this point, the officer
admitted to lying to the police. Cool.
Exactly.
Cool.
Great job.
Cool.
So at this point, Officer Leroy concludes his investigation. He lets the stepdad know what he found. And at this point, EB's stepdad doesn't seem too thrilled with how things played out.
Oh my gosh. Can you, I'm trying to imagine that. I'd be so upset.
Yeah. So he testified later that he felt he had been manipulated by EB.
You don't say.
Yeah, there you go. So now the stepdad's like, all right, my stepdaughter, not cool. All right. So that night he sends an email to the school board, the principal, the superintendent, and he admitted that he had an inaccurate version of the events and that Miss Cerrone did not look under the stall door in an inappropriate way.
Okay. So the stepdad's kind of just admitting
he's admitting it. I don't know if he's apologizing or not, but he admitted it.
Okay. That's a step.
Yeah. And another step, EB sends an email to Miss Cerrone acknowledging that she had lied. I'm assuming it was sort of an apologetic kind of email. I'm sorry I lied.
Yeah.
Okay. So now the truth is out. Everything goes away. Police investigation taken care of. It's not the end of the story, though. The school decides we have an issue here.
Right.
Okay?
Yeah. What's the school going to do about all this?
Yeah. Well, think about this. Okay. You had a police investigation. You had an accusation that one of your teachers was
being inappropriate.
Essentially being inappropriate in a bathroom with a kid. That's not cool. Right. And as a school,
that's serious.
Yeah. How are we going to deal with this? We had a kid who caused a whole bunch of stuff, not good stuff for our teacher.
And if it's true, we got to do something about this teacher.
Exactly. And if it's not true, what are we going to do?
Something about this student.
Exactly. So the assistant principal speaks with everybody. AL, she tells the assistant principal that EB had been vaping in the stall with SN. AL also confirmed that EB had asked her to lie about what Miss Cerrone did. And AL also told the assistant principal that two of EB's friends told her that if she didn't cooperate EB's version of events, EB would take AL out to the field and leave her there, which AL interpreted as a threat that she would be buried.
Wow, that escalated quickly.
Yeah, I know. It gets better and better, man. It's like, are there more rails?
I was going to say, I didn't know the mob was running in this school.
Yeah. We're going to make you an offer you can't refuse.
Exactly, right? Like, you're going to be swimming with the fish.
Listen here, see? So everything is not going well for EB here. EB has not used her power for good, apparently.
Right. Yeah, things aren't looking good for her.
So AP meets with EB, the AP meaning the assistant principal, meets with EB and her parents on May 9th. And at that meeting, he gave them a prepared letter stating that EB had been suspended for 10 days and that there was going to be a recommendation for her expulsion to the Board of Education for 180 days. So basically a full school year. All right. And the reason for that recommendation was the quote intimidation that EB did towards this other student, AL. And the letter detailed that EB had made up a false story, that EB and her parents had filed a false police report accusing Miss Cerrone of wrongdoing. So basically, this letter is calling out everything that had happened and said, because of all this, we are recommending expulsion because this is some serious stuff.
Right. Yeah.
So
I get it.
They hold an expulsion hearing. Board of Education holds this hearing, and EB and her parents were notified of the hearing as per the standard procedures, right? They were represented by counsel at the hearing. Their lawyer presented EB in the parents' side of the story, and both EB and her mom testified. So it was like a full process at this
hearing. Got hearing, you got evidence, you got cross-examination, you got lawyers. It's not quite a courtroom, but it sounds pretty close.
Exactly. So after all this, the school board determined that based on a preponderance of evidence, EB had engaged in conduct that involved intimidation of another student, that she had made false statements accusing an administrator of a sex crime, and that those statements had led EB's stepdad to file a false police report against Miss Cerrone. The school board expelled EB for 180 days, but did say that she was permitted to petition for early reinstatement. So, decision made, and a few months later, EB petitioned for reinstatement. This was in December of 2022. So she was expelled in May. She petitioned in December, and the superintendent allowed her to be reinstated in January of 2023. So basically, she was expelled for half of the amount of time that she was recommended. So she
basically missed fall semester.
Yes, she missed fall semester.
Of her, what? That would be her junior year?
Yes.
Yeah.
And, and if you didn't think that this nonsense was over at this point.
Right. I mean, everyone learned their lesson. They all went home.
Yeah. Right.
Got on with their lives.
After all of that, the parents decided to file a lawsuit.
Right. Well, which I guess is good because it gets us a chance to talk about it because, we talk about lawsuits.
Yes.
So, the parents filed a lawsuit because, why not?
Why not? We've come this far.
Right. Like, maybe that's what it is. Like we talked about like doubling down and throwing good money after bad. Like
in for a penny.
At this point, in for a penny, in for a pound. Like, I guess, sure. I don't know if it's teaching the right messages, right? Like, because the stepdad at least already knows that he's been kind of not manipulated, but like misled at the very least.
Maybe the decision in this case sends the right message, but
which, there are hard cases and then there are easy cases. Let's figure out which one this is. I think we probably already gave it away. This is a pretty
this is an easy case.
Court.
So what are the different constitutional violations that these parents are claiming?
Well, this is another one of those spaghetti lawsuits.
Yeah.
Actually, throughout the opinion, the court kind of goes out of its way to poke fun at the plaintiff's attorney. So like, I can't imagine they were getting the best representation because at one point the court even says like, it was not what did they say? Like, it's not a paragon of clarity. I think they say that about one of the plaintiffs' like opinion or briefs. Anyway, nice. You'd never want to see that if you're the attorney in a judicial opinion. So the family brings this lawsuit. We're in federal court because they're alleging 8 different claims for relief, many of which are constitutional claims.
Okay.
So you ready? Here we go. We got First Amendment claims alleging that the school violated EB's freedom of speech when it expelled her for her false statements and when it retaliated against her and her mom for their advocacy following the initial vape search that didn't turn anything up. Basically, they're saying like all of this is retaliation because we stood up for ourselves and you shouldn't have suspended and expelled her for her speech because it didn't cause a material and substantial disruption or invade the rights of others.
Well, that's tinker, but that's very interesting because they're saying punishing her for her speech, the lying and all of that stuff. Well, the law has been pretty clear that like making false accusations is a problem.
Right. Yeah. Knowingly false accusations and defamation of others isn't necessarily protected speech.
Exactly.
Right?
Exactly.
Yeah. Yeah. So the First Amendment, like we can already kind of see there's going to be some problems there.
Yeah.
We've also got some Fourth Amendment concerns, reasonable searches and seizures.
Yeah.
The family is saying that both the initial vape search, the no contact initial vape search, and the peering under the stall doors, both of those violate the Fourth Amendment.
But we've already talked about how those probably don't. So there's another problematic claim.
Yep. TLO pretty much on firm ground there.
Okay.
We've also got procedural and substantive due process allegations here, which is that the school didn't give EB enough process before it expelled her or suspended her.
Yeah, those are things like the providing notice of a hearing, allowing them to come to the hearing and present evidence and do all of those different steps.
Right. Which
we know happened. So,
not looking good again.
All right.
And then the substantive due process one is basically saying that, even if the process was fair, the decision isn't justified by the government's interest. So basically
which is we've talked about how that's a much harder thing to overcome. And
right. It has to shock the conscience in this context. And that's such a huge bar. Yeah. We've talked about other stuff that is more conscious shocking.
Right.
Like, taping a kid's head to a tree.
Yeah, exactly.
That case?
Exactly. Yeah.
Yes. And then the last claim they bring is a breach of contract claim because why not? The court doesn't get into it because it's a state law claim. And the court was like, I'm not going to touch that. I'm just going to deal with the constitutional claims because guess what? Y'all got nothing. So we've got First Amendment claims, Fourth Amendment claims, 14th Amendment claims. The family at the beginning of the lawsuit kind of files a motion for an injunction or a restraining order or something like that to get emergency relief to get EB back in school to get her reinstated. The court denies that request. for me, like that might be the strategy of why they did this, is just to like, can we get this expulsion lifted before we have to apply for reinstatement? So maybe trying to get her back in school for the fall. But
oh yeah, because all of this, sorry, I think we forgot to mention the lawsuit comes while she is under expulsion in the fall. She petitioned in December, but the lawsuit
this was filed
happens
in September.
Yeah.
Sorry about that.
Yeah,
so this was filed in September. So they're trying to get probably like preempt the reinstatement.
Yes, exactly.
Yeah. So we've got these constitutional claims. The court doesn't offer preliminary relief. So about a year later, the school files for summary judgment. They say, look, this has gone on long enough. Based on the evidence we've got, we win. And the court looks at that and says, yep, I've got all the evidence I need. Let's make a decision. So let's talk about EB's constitutional claims. We've already kind of previewed how maybe there's some challenges here to make these claims. So, the First Amendment, we've talked a ton about student First Amendment rights. If you haven't listened to our 50th episode with Mary Beth Tinker from the famous Tinker case from 1969, it's episode 50. Might be my favorite episode. It's so good. But, the First Amendment in schools, there's really kind of like 4 categories of student speech that schools can regulate.
Yep.
We've got indecent, offensively lewd, vulgar speech. That's Bethel versus Frazier. We've got speech during a school sponsored event that could reasonably promote illegal drug use. That's Morse v. Frederick. We did that case too.
Mm-hmm.
We got to go back and do Bethel.
Yes,
it's a really fun case.
We got to do Bethel. Yeah.
And then you've got the third category, which is speech in school-sponsored expressive activities, which is Hazelwood, which we also haven't done, which we need to do. And then the last one is Tinker, which is on-campus and some off-campus speech that materially disrupts classroom environment or the school or involves invasion of the rights of others.
Right.
And that's Tinker mixed a little bit with Mahanoy, because Mahanoy, which I think was episode 3, we've definitely done Mahanoy.
Early on. That was the off-campus speech.
That was the cussing cheerleader, right?
Yeah.
And so that kind of tells us when schools can regulate off-campus speech. So everyone agrees we're kind of in the 4th bucket. Tinker.
Yeah.
This is, is there a material and substantial disruption? Is the speech invading the rights of others? And, is there a sufficient connection? If it does occur off campus, is there enough of a connection between the speech and the school?
Yeah.
And all of those are pretty easy for this one, I think. And the court agrees, because the court says, hey, accusing school administrators to the police regarding admittedly and knowingly false statements. Yeah, that not only threatens disruption to the normal operation of schools, because, think about all the fallout that came from that. I think there was reports that...
And it's an accusation of a potential sex crime.
Right, yeah.
It's huge.
It's serious. And that goes to the second part about like invading the rights of others, right? So like not only did this cause Miss Cerrone to like basically lock herself in her office for days after this thing, like, quote, according to the court, sobbing hysterically. Cause like imagine being the teacher receiving all of this, right? Like it's disruptive. It invades the rights of others. And like, we know that she knew that this was false. So like, that's all pretty easy.
Yeah.
The off-campus student speech stuff. So we got to kind of like grapple with Mahanoy there. But Mahanoy even said like one of the reasons that schools can regulate student speech off campus is if that
causes a problem on campus
and is directly targeted at specific individuals and is like, and it constitutes harassment, right? Like, what is this if it's not that?
Right. Exactly.
Right.
Exactly.
And so the court looks at this and says like, no, I'm pretty sure we're in Tinkerland, and I'm pretty sure Mahanoy applies to this because that's one of my green lights is speech that
targets,
is serious or severe bullying or harassment that targets particular individuals. I've got a material substantial disruption. I've got invasion of the rights of others. EB argues that she's not really responsible for this speech. She says like, oh, well, it was my dad who filed the police report, my stepdad who filed the police report. So that wasn't me. And then also I was just going off of what AL said. So it's really AL's fault that I misinterpreted what she said. And then my dad misinterpreted what I said. And that just kind of snowballed out of control. So like, really, it's just a bad game of telephone.
Great. That doesn't fly with me. It doesn't fly with the court.
No, the court laughs her out of court. No, they probably don't, but they don't buy it. They basically say like, no, you knew what you were doing. This is fairly on you.
Okay. So what about due process?
So due process, exactly what we kind of already said, like For procedural due process for a suspension of 10 days or less, Goss versus Lopez says you need notice in a hearing, which is notice, an opportunity to hear the evidence against you, and an opportunity to tell your side of the story. Those are all done. Like when we said, like, hey, here's this letter. Here's what you're accused of. Do you have anything for you to say for yourself? Bam, suspension. Okay, well, I'm going to recommend you for expulsion. Obviously, expulsion requires a bit more process because it's a greater deprivation. The more significant the deprivation, the more process you get.
Right. But they get a full hearing with a lawyer and the...
Right. And there's no Supreme Court case on that. So a lot of that's state law stuff.
Yeah, exactly.
You know, there's been cases about like you get the opportunity to get advance notice. You can bring a lawyer if you want one. You can call witnesses. You can cross-examine witnesses. Like it's
all
not
kinds of stuff.
A courtroom, but it's, you know, it's much more like a courtroom than that quick informal hearing that you get for a suspension.
Diet court.
Exactly. So all of that was done here. So there's really no procedural due process issues, the court says. So sorry, you don't win that one either. Substantive due process, same story. In this context, like to show a violation of substantive due process, it has to be one of those, quote, rare cases where there is no rational relationship between the punishment and the offense. Otherwise, that would shock the conscience, and we don't want the government to do arbitrary stuff, obviously. But it has to shock the conscience. The punishment basically has to be so unfair that there's no reasonable
connection,
explanation or justification.
Yeah.
And here, like, I don't know about you, Jamie, but this all feels pretty reasonable.
Oh, it's pretty reasonable.
Yeah. So no substantive due process violation.
Okay.
And we've already talked about the Fourth Amendment stuff. Was it justified at its inception?
Right.
Reasonably related in scope.
Yep.
Obviously, the no contact visual inspection for the allegations of vape, like we had a student witness who came forward. They were credible. There's no reason to doubt them. That was all justified. It was minimally intrusive. We were looking for something against the rules, potentially against the law too, because you know, vapes and whatever. And then the bathroom stall, same story, like justified at its inception. Sure, there was suspicion. There's a practice or a history of, you know, students vaping in the bathroom. There was this reason to suspect these particular students. Minimally intrusive. You're in the back of the bathroom, far away from the stalls, looking under. You know, that's all stuff that, you know, you might even see just without even looking for it, right? Just given the way bathrooms are designed. So all of that is to say the searches pass constitutional muster. So no Fourth Amendment violation here either. And that is it for EB's constitutional claims. So the court says, look, there's no constitutional claims here. I'm going to grant the school's motion for summary judgment. So case dismissed.
There it is.
And that's the end of the case.
Finally.
Right. Yeah. Like all of this started with a 2-second crouching down to like look to see if there were too many people in a bathroom stall.
Right. What are the big takeaways here? Like, you know, we talked about how there were so many places in this situation where it didn't have to go off the rails, but it went off the rails. Right. There were, I don't know, 3, 4, 5, 6 times where if something had just happened a little differently, could have ended everything right there. You know, could it have been a relationship thing between the parents and the schools? Entirely possible. We don't know.
Right. And it could have like helped, right? Like I think the school handled this really well because there's this student who is just kind of like exacerbating the situation over and over again and like kind of doubling down.
The school kind of didn't get into any sort of retaliatory posturing or anything like that. They just kind of stuck to their guns in terms of, you know, enforcing their policies and, you know, conducting their investigations and not running afoul of the law and whatever. And, you know,
they took their time. They did the investigation. They followed their procedures. Like all of that sounds great.
Yes. Yeah. So I, you know, like it's hard to say exactly what could have kept this thing from going off the rails, but we do know there are a number of things and there were a number of opportunities. Most of those were squarely in the sort of the realm of EB's responsibility, right? Like EB controlled the way this whole thing went down, right?
Right. But in response to that, like, you know, this is one of those situations where like it quickly came to light that wasn't necessarily what happened, right? For me, the question I keep coming back to is like, could you have avoided all of this if the school had notified EB's parents of the initial search for the vape in April?
Before
because that was their sticking point, right? Like if maybe like if there was something proactive the school could have done to avoid angering these parents initially, But even that, like, there's always going to be parents that like you can't appease.
No, like some parents might have been like, I don't want you searching my kid without me being present. And then maybe the school decides, well, I'm going to try to avoid a fight here. So I'm going to search the kid while the parents are present. And they conduct the exact same search in the presence of the parents, right? And they find nothing. And then the parents get even more mad.
Why'd you do that in the first one? Yeah.
Right? So it's all speculative. It's hard to say for sure.
But what we do know for sure is no constitutional violations.
Exactly. There's a lot to that story. That was a long story.
This was a more dramatic story, I think.
Yeah, definitely. But, listen, this is the kind of stuff that goes on in schools.
Day in and day out.
High school, and there's a lot to it. There's manipulative behaviors. There's lying. There's kids being kids, which is pushing the envelope and trying to figure out where the boundaries are. And sometimes kids do that in a way that causes a lot of problems for themselves and for others.
Right. And in this case, there was some accountability for that. Right?
Exactly. Again, like this is what happens in schools because kids, they're going to be kids. And sometimes that comes with a lot of drama. But it is what it is.
Yeah.
All right. Well, we hope you enjoyed that one, folks. Chris, what's our homework?
Your homework is to...
Don't try to get away with a lie by lying some more.
Right.
Just go into the bathroom and use the bathroom and go back to class.
Yeah, your homework is to not loiter in the bathroom. So with that, please like, rate, and review Chalk and Gavel wherever you get podcasts or video podcasts, because you can also find us on YouTube.
Yeah.
We've got our teaching guide on our website if you want to assign Chalk and Gavel to your classes or for professional development for your staff, whatever it might be. You can find us at chalkandgavel.com. There's a feedback form there. We'd love to hear your thoughts. You can find us on social media at Chalk and Gavel. And I think that's pretty much it. Oh, Patreon.
Yeah.
Please support us if you like what you hear.
$2
a month goes a long way to keeping the lights on.
Okay, everybody. Thank you for listening once again, and we will see you in 2 weeks. Have a good one.